Gavin Newsom, the governor of California, is throwing a hissy fit. Welcome to another installment of the Connecticut Gun Bench. Today's video is brought to you today by P.A.N. Firearms LLC. P.A.N. Firearms for your NRA certification and multifaceted gun training. You can reach us at 203-300-6343 or use our website at www.panfirearmsllc.com. As always, there'll be a link in the description box below. But let's talk about this. Gavin Newsom, governor of California, in response to the Supreme Court's ruling on the Texas abortion ban, has decided to make a ban of his own. So, for the sake of context, I have to give you the background. Texas passed an abortion bill on September 1st, 2021. Basically what the abortion bill does, it allows private citizens to sue abortion providers if they provide an abortion. And right here from the Legal Examiner, September 21st, the Texas abortion restriction law known as SB 8 or the Texas Heartbeat Act went into effect. This new Texas law restricts the timing of abortions to before fetal cardiac activity can be detected on an ultrasound. It is estimated that this can be around 5 to 7 weeks of pregnancy. The challenge with this is that most women are unaware that they are pregnant at this time. This law conflicts with the Supreme Court previous ruling that only permits abortions up to the gestation of 22 to 24 weeks. Up to this time period, a fetus is not viable. Obviously there's a massive argument there, but that's what the Supreme Court ruling says. It is expected that this law will restrict 85% of abortion procedures in Texas. This law effectively bans abortion for everyone once an electric activity has been seen on an ultrasound. If the mother's life is at risk, there is a language included in the law to permit emergency intervention from doctors. But experts agree that the language is vague, creates gray areas, and could put patients' lives and health at risk. If statutory rape resulted in a pregnancy, the pregnancy would not be allowed to be eliminated. The same holds true for those who become pregnant through incest. Additionally, if fetal abnormalities could result in fetal death or the diagnosis of fetal disease, SB 8 will prohibit the termination of a pregnancy. So far, Texas restrictions on abortions are the toughest in America. During the upcoming term of the Supreme Court, Mississippi's ban on abortion after the 15-week mark will be on the docket. Now, this is where it gets interesting, shifting enforcement by government and law enforcement to private citizens. The Texas Heartbeat Act allows private citizens to sue abortion providers or anyone else they suspect of helping women obtain an abortion. This law shifts the method of how laws are normally enforced. This act removes the government and law enforcement from enforcing the act and hands the enforcement over to private citizens. It is believed to be the first type of law enforced by private citizens. Now, what has happened, of course, is that there is a case in the Supreme Court. And I believe it's Women's Health versus Jackson. The Supreme Court has decided to allow the abortion lawsuit to proceed, but has not declined to halt the enforcement of it. In this U.S. News article titled, Supreme Court Allows Texas Abortion Lawsuit to Proceed, Declines to Halt Enforcement, the ruling was a split decision allowing a case brought by providers against the controversial ban to continue, but dismissing a Justice Department attempt to block it in the meantime. The Supreme Court on Friday ruled that abortion providers can proceed with their challenge to a Texas ban on abortions performed after 6 weeks of pregnancy, but with that narrow victory, the court still left the controversial law on the books and declined to halt enforcement as the case moved forward. In the majority opinion for Whole Women's Health versus Jackson, abortion clinics can keep up their challenge in lower federal courts, though it significantly limits who can be listed as a defendant in the case. In an 8-to-1 vote, the justices allowed state licensed officials to still be sued since they have the authority to enforce the law. Justice Clarence Thomas was the lone dissenter. Now, what has come from that is Gavin Newsom has thrown his hand into this situation. And basically what he has done is kind of in a counterploy, if you want to call it that, has decided that he is going to make his own little private citizens ban, or where private citizens can sue, but not on abortions, but on guns. Once again, I go to this U.S. News article. Newsom's California gunplay tests GOP's Texas abortion law strategy. The California governor's pledge to use the precedent of a novel Texas abortion law to pass gun restrictions is likely the first of a slew of similar measures targeting any number of rights and issues. California Governor Gavin Newsom is pledging to create a new law allowing private citizens to sue anyone making or selling assault rifles, mirroring the novel mechanism of a controversial ban banning nearly all abortions in the state of Texas. But imitation in this case is not a form of flattery. Newsom's proposal is a sharp escalation in the partisan battle over the Texas abortion restrictions and comes as a direct response to the Supreme Court's ruling last week, which I read earlier, allowing the ban to stay in place while legal challenges of a limited scope are permitted to continue. The proposal, which partly a calculated political play, which is really what it is, also may be the beginning of what some legal experts say could be a slew of similar laws using the same mechanism to target any number of rights and issues privileged by both the left and the right. On the other side of the political spectrum, if you know somebody who tries to exercise their right to same-sex marriage, you can imagine a state legislator allowing suits against people who are providing services on an equal basis to same-sex couples or something like that, says Michael Dorf, a law professor at Cornell Law School and expert in constitutional law. For now, though, the issue is guns. And in the case of the California law, if created and passed, it would mark the realization of grave concern by some gun rights groups that have found themselves unusual allies with abortion rights advocates in opposition to the Texas measure. It started when Newsom said he was outraged by Friday's 5-4 ruling by the Supreme Court's conservative majority allowing some, but not all, legal challenges to continue. If states can now shield their laws from review by the federal courts that compare assault weapons to Swiss Army knives, then California will use that authority to protect people's lives. This is very interesting wording. What he is referring to is a California federal judge who basically said that California's assault weapons ban was unconstitutional. And that judge in that decision said that assault weapons are as common as Swiss Army knives. That's where he's getting that verbiage from. But the fact that he says authority to protect people's lives. Okay, so obviously that means some people, because abortion is ending a life. Where Texas used it to put women in harm's way, Newsom said in a statement Saturday, referencing a ruling in June by a federal judge finding unconstitutional California's ban on the manufacturing and sale of assault weapons and comparing the AR-15 to a Swiss Army knife as the perfect combination of home defense weapon and homeland defense equipment. The Democratic governor said he directed his staff to work with the state legislature and attorney general on the creation of a bill allowing private citizens to seek injunctive relief and statutory damages of at least $10,000 per violation plus costs and attorney's fees against anyone who manufactures, distributes, or sells an assault weapon or ghost gun kit or parts. Letitia James, Attorney General of New York, said Tuesday on a talk show, The View, that she was interested in following Newsom's footsteps. Newsom's proposed measure is a almost perfect imitation of the Texas abortion ban known as SB 8, which bars abortions after fetal cardiac activity is detected, typically at about 6 weeks before many women know they are pregnant. The law places the enforcement of the ban not in the hands of the state, but in the hands of private citizens who can sue anyone who aids a woman in getting an abortion for at least $10,000 in damages. That enforcement scheme has by design made it extremely difficult to challenge the law in court, despite the fact the ban violates the constitutionally protected right to an abortion recognized by the Supreme Court. Nowhere in the Constitution does it say that you have a right to abortion. But Justice Sonia Sotomayor raised the prospect of copycat laws in a dissent. The majority's opinion clears the way for states to reprise and perfect Texas' scheme in the future to target the exercise of any right recognized by this court, with which they disagree. This is not hypothetical. New permutations of SB 8 are coming, Sotomayor wrote in the dissent, in which she was joined by Justice Stephen Breyer and Allegra Kagan. Some gun right activists have warned for months that the Texas law could backfire and be used as a blueprint for blue states to go after gun rights and other issues cherished by the right. The Firearms Policy Coalition, a brash gun rights nonprofit, filed a brief with the Supreme Court in opposition to the Texas measure, warning that similar laws could be used to bypass other rights. It is hardly speculation to suggest that if Texas succeeds in its gambit here, New York, California, New Jersey, and others will not be far behind in adopting equally aggressive gambits to not merely chill, but to freeze the right to keep and bear arms, the group said in a brief. It is also noted that similar mechanisms could be used to go after anything from same-sex marriage to protests to people who refuse to wear masks or get the coronavirus vaccine. A private bounty scheme could easily be modified to target persons who marry someone of the wrong sex or color, criticize the government, refuse to wear masks or get vaccinated, make negligent or harmless false statements on public issues, or engage in any other protected but disfavored conduct, it said. The group, when asked for comment, pointed to a statement released Saturday in which it said it had predicted that tyrants like Gavin Newsom would use the Texas model against fundamental human rights, including the freedom of speech and the right to keep and bear arms, and pledged to fight Newsom's war on the human rights head on. Now, I will leave this article, as always, in the description box below, but what is going on here is Newsom is basically, like I say, having a hissy fit, because he's saying because Texas is banning abortions at 6 weeks, he's now using that as a framework, foundation model to then say, well, we're going to sue, or I'm going to allow private citizens, not so much the government, private citizens to sue anyone who makes an assault weapon when that weapon is used nefariously. This is obviously a direct violation of the Lawful Commerce Act, the Lawful Commerce and Arms Act, which shields gun manufacturers from lawsuits when somebody uses their product in a nefarious manner, which is common sense. You can't sue somebody because they make a legal product, and then somebody turns around and uses that product in a deceitful manner. And he's playing politics, which is normal. It's just the way it is. But he's using it in what I consider a deceitful manner. Now, he already had an issue when the judge said that the assault weapons ban in California was, is unconstitutional, which I sure irked him quite heavily. So now he's kind of falling back on this Texas abortion ban and what the Supreme Court has done to now push this strategy out there. And it's correct. If he were allowed to get this in motion, other states will do it. And then we'd have to go through a long legal, battle to prove that, it's unconstitutional. You can't sue somebody over a legal product because somebody uses it in an idiotic manner. We just had, very briefly, December, the Sandy Hook anniversary. And it's interesting how many people are rushing to say, remember the victims, remember the victims. And yet November 1st was the anniversary of this incident in New York where a person took a Home Depot rental truck and deliberately ran over pedestrians and killed 8 people. No one's coming out to say and remember those victims. Why not? Did they not murdered just as much as what happened at Sandy Hook? These people are all in the same position. They're all unfortunately dead. Just because the mechanism used to cause that death was a truck and not an assault rifle does not make their deaths, negate their deaths or downplay their deaths. But this is how the game is played, and it's unfortunate that we're going through this. If Gavin Newsom manages to get this thing passed and it becomes law, it's obviously going to go to court. And based on the law, already established law, the Lawful Commerce and Arms Act, it will be overturned because it is unconstitutional. But going back to the U.S. News article here, somebody's quoted here saying what Governor Newsom is proposing does operate in the area of uncertainty. Of course it does. He is not proposing SB 8 style private litigation against all gun owners. It's against owners of assault rifles, and the law is currently uncertain with respect to assault rifles, Dorff said. Religious exemptions may fall into that bucket of uncertain scope as well, he says. That's correct, because then private citizen can just go out and say, well, this religious institution does not recognize same-sex marriage or does not recognize certain aspects that I believe in personally, so I'm going to sue them as a private citizen. And this just opens the gate to a whole plethora of really, really bad and unjust lawsuits against people based on the emotional feelings of someone who may have been emotionally harmed. But that view bucks against what the Texas Solicitor General, Judge Stone, told the High Court in November during oral arguments. Stone was asked by Justice Brett Kavanaugh if, according to his arguments and the scheme of the Texas measure, a law allowing citizens to sue anyone who sells an AR-15 for $1 million in damages would be exempt from pre-enforcement review at the federal level. Stone said, without action from Congress, it would. As I said before, if this were to come to pass and it would go into court, it would be overturned because it's unconstitutional, and it's a violation of the protection of law, protection clause for the Lawful Commerce in Arms Act. It's unfortunate that we're using life as kind of a, like a juggling act, because in both cases, a life is involved. Abortion, a life is involved. When somebody kills someone, a life is involved. But in the case of when a firearm is used, that's a nefarious action, a deliberate action on the part of another individual who then goes out and harms someone else. You can't sue somebody for doing so. It's the same thing as I mentioned the Home Depot in New York, where the Home Depot truck person used it to kill 8 people. How far could you go? Would you sue Home Depot, the manufacturer of the truck, the manufacturer of the engine of the truck? I mean, it just gets ridiculous. But this is obviously a direct attack, and it unfortunately may open a door for other states, New York, New York, potentially Massachusetts, Connecticut, to impose or to come up with their own version of this thing, where all of a sudden gun manufacturers will find themselves in court continuously over nefarious use of their product. But let me know what you think. As always, leave your comments in the comments section below. Any calls for violence or statements to violence will be deleted. Please like, share, and subscribe. Hit the notification bell so you get notified the next time a video goes live. And I will see you on the next one. Peace.